let's take a turn to native title.
Yes.
So could you describe to us what Terra Nullius is and what native title is?
Yes. The thinking of Europeans in the certainly up to the late 20th century, but certainly in the 19th century, in the 1800s and earlier, was that Europeans were advanced people, and the whiter you were, the more advanced you were. So, English people were more, and Germans were more advanced than Italians and Greeks, and much more advanced than Turks and Arabs. So that was a given. Everybody believed it. It was just a truth. So when they came to somewhere like Africa or Australia, when they came to Australia relevantly, and they saw groups of indigenous people who were black and who didn't have any evident signs of law or judges or institutions of that kind, they were very ready to dismiss them as savages who are of no account, hardly people at all, certainly not people who claim to own anything. And therefore, if you come to Australia and there is nobody who owns anything, nobody who owns the land, then the land is empty. And Terra Nullius is Latin for empty land. That means then that the people who first claimed to own it, the white British who came here and asserted ownership of it, can be said to be the owners of it. Simple, no problem. And there was a case in the Northern Territory in which the legal doctrine of Terra Nullius was applied to deny Indigenous claimants, to deny that Indigenous claimants over land had any rights over the land because they didn't own anything. That changed in a case called Mabo in the High Court, and that case was further refined in a case called Wik, W-I-K, in which I appeared for the Wik people. So what happened with Mabo was that by a process of historical reasoning and an examination of anthropological evidence, expert evidence about how Indigenous society in Australia worked, it was seen very clearly that Aboriginal society did have laws that applied as you'd expect. You can't have a community of human beings living together without laws. There must be laws. Moreover, they had laws about property, so that one group of Indigenous people living here in this territory regarded that as theirs, and other groups of Indigenous people living nearby regarded the land that they lived upon as theirs. And what's more, they recognized the ownership of the land by the first group. And they had elaborate rules for how you deal with each other in terms of sharing the use of land or entry into land and matters of that kind. And once you recognize that, then you have to reject Terra Nullius and say that no, that there was a pre-existing set of laws. And the question for the High Court was, having found that there was a pre-existing set of laws that Indigenous people applied to land, and this was a case about land, the question arises, how do Aboriginal laws and European laws in Australia, by Australia, we can say Australian laws made by Australian parliaments, how do they interact, where they collide or conflict with Aboriginal law? Aboriginal law, for example, says this land belongs to this clan group of people. Australian law says this land belongs to the Crown, the state of Queensland, and the state of Queensland has given a lease over part of it, including over the what the Aborigines say is their land, has given a lease over it to this person who's now running cattle on it. So that cattle grower says, I can go into that land anytime I want because I've got a piece of paper authorised by Queensland law that allows me to do it. The Aboriginal group says, no, you can't because we're the owners of this land and you don't have any rights from us. So that's a conflict. How do you resolve it? What Mabo decided was that the resolution is in favour of modern Australian law, but only where it conflicts uh, uh, in an irreconcilable way with Aboriginal land. That is to say, if person A is given absolute ownership, complete ownership, the way that you have over land that you buy and live in your house as the owner of that land, if you're given that kind of right of ownership, then anybody, Aboriginal or not, who said that I had rights before you, don't have those rights anymore. So they resolved it in that way. Now, the way I worked it out in my mind was this. That struck a lot of people as, a lot of people resented that and got very angry that the High Court had said that, because it struck a lot of people as contrary to modern thinking and all the rest of it. So there are arguments that you can look up. But the way I thought of it and explained it to myself was this. After World War II, at the end of World War II, Japan had surrendered. And in Japan, on the date of surrender, if we just take that point, there was a man who owned a house in Tokyo on a little plot of land, and he could produce the piece of paper that the Japanese government had issued to prove that he was the undisputed absolute owner of that piece of land. At the end of World War II, the American armed forces went into Japan and occupied it. And the leader of the American forces, General Douglas MacArthur, became the controller of Japan. And he had the authority under American law to issue laws. And a law that he could issue would be one that said to this Japanese man with his house, by this law, you lose your ownership because we need your house to build some housing for soldiers, and we're occupying, so the soldiers have to be there, so we're going to tear down your house and we're going to build barracks. So your ownership is gone. He had the right to do that. And there's no doubt that he had the right to do it. And that his dictate would overpower any pre-existing Japanese law that said to the contrary. But until that happened, the Japanese man remained the owner. Nothing changed. The fact that the Americans occupied Japan in the sense that they were the force, the lawful force there, didn't change anything until a specific action, executive action or legal action by MacArthur changed it. Now, MacArthur could have said, here's a piece of paper, we need to house our soldiers, and this piece of paper, it creates a law that says any American soldier that we send has the right to sleep in your spare bedroom. Now, that would apply so that the Japanese law that allowed the Japanese owner to exclude anybody he wanted would no longer apply to that soldier. It would apply to everyone else, but not that soldier. So he still had his rights, but they were reduced a little bit. Now, but until that happened, he had his complete rights. So the way I explain native title to myself is that Aboriginal people had their laws, they had their ownership. A law of the Queensland Parliament says, I'm going to give a crown lease to this person to run cattle on that piece of land. That cattle grower goes onto that piece of land and, pursuant to that piece of paper, has the right to introduce cattle and to walk over the land where necessary to grow cattle, not for any other purpose. And to that extent, Aboriginal rights in the land are reduced, but only to that extent. If the Queensland law said he gets total rights, the cattle grower gets total rights to the land, then all of the Aboriginal rights disappear forever. So that's what the High Court decided in Mabo, and that's what they decided in Wik when they said that the grant of a pastoral lease, Queensland's covered with pastoral leases. If pastoral leases, if extinguished native title totally, there'd hardly be any native title in Queensland, maybe none. But because pastoral leases only granted rights to run cattle, the High Court decided it was only a partial reduction in Aboriginal land rights, not a total reduction, which was a huge step because the fear was that pastoral leases had the effect of totally extinguishing native title. So that's native title in a nutshell.
Wow, thank you for that.